an interview, Sadia and I interviewed Iaroslav Gregirchak, that talk about a last name that was going to be difficult to pronounce, but in the segment I pronounce it correctly. He's the Deputy Business Ombudsman for the Business-Ombudsman Council in Ukraine, in Kiev. And what we talk about, Sadia and I talk with Iaroslav about, is this means of an alternative dispute resolution before something actually does manifest into a complete arbitration, or in lieu of. So it's I think it's a really interesting initiative and a lot of buy-in domestically. So it's just bringing a new perspective to the podcast. Again, part of our goal for this season was to bring different participants into the conversation. Then I interviewed Andre Luis Monteiro, who is from Queen Emmanuel, counsel at Queen Emmanuel, hailing from Brazil, and we talk about the intersection between insolvency and arbitration. And we think that it is very apropos at this day and age because of what is happening in what we perceive to be an economic crisis on the horizon for companies post-COVID. So we think that arbitration may be seeing a lot of elements of insolvency creeping its way into the arbitral proceedings and the impact they may have both before, during, and after the arbitration.
Yeah,
that
really
is great.
Interesting.
Yeah, and then we have less substantive, less prepared, less structured, happy fun time about Manals, since we're recording on 8th of March.
You're
Manals,
the one who qualifies Manals as a fun time, as opposed to International Women's Day as not a happy day. For the record.
No, it's all consistent. It is all consistent. My issue is that we're supposed to be talking about issues and how to address them rather than patting each other on the back. This is what we're doing for Happy Fun Time. We are having a happy fun time by contributing to a conversation, not buying flowers and saying nice things.
Oh my gosh, we're gonna have a whole segment on how to celebrate something. That would be
I can't wait for that segment just to see how to hear Jill's perspective on this. Yeah.
No, yeah. Sadia, you will definitely have to contribute, but we can, as allies, what we can do when you face a male panel. I don't think we've defined it yet. But.
Yes, a manel.
I tried. I was about to give a whole intro, and then Sadia just stabbed me in the back with a fork.
Sorry.
Interrupted.
A manel. It's you two minus me. That's a manel.
That is a manel. We almost did. We maneled for a few seasons, and now we did. Now we're a panel. All right, let's get started before any blood is drawn. Can you pronounce your last name as well? Sorry.
Oh, yeah. Yeah, well, so sorry about that.
Don't apologize. It's for us.
Gregirchak. Yes, Gregirchak. Gregirchak, yes.
Iaroslav Gregirchak. Is that okay?
Yes.
Okay.
Yeah. It doesn't even sound sort of conventionally Ukrainian in a sense, because I am originally from western part, from the Carpathian Mountains, and I guess, yeah, that's where the roots of the surname come.
I mean, we're already recording. I think that's a great start.
That is a great start.
Can you just explain where that root would come from the Western Ukraine?
It's the region called Transcarpathia, which not that large when it comes to the area that is occupied by the region, but nonetheless, it has borders with Romania, Slovakia, Poland, and Hungary.
I see. Interesting. Well, thank you for coming. So we have Iaroslav Gregirchak with us today, and we are very excited about this topic because we're branching a bit away from arbitration, but we're still in the realm of an alternative dispute resolution. And Iaroslav, you are a member of the Business-Ombudsman Council. Is that correct? Is the title member, or what is the title? Are you an ombudsman?
The title is Deputy Business-Ombudsman of Ukraine.
Okay.
So what does that mean?
Yeah, what does that mean?
Yeah, indeed. That's substantially, it means that I am the part of the management team tasked to manage the activities of the Business Ombudsman Council, which is somewhat unconventional example of the specialized ombudsman mechanism tasked to accept complaints specifically from businesses and probably investigate instances of business malpractice that are specified in those complaints. And indeed, while doing so, we are operating on the basis of the traditional international principles attributable to any ombudsman institution, which is independence, impartiality, and confidentiality. Of course, by definition, we are not vested with any binding authority. We exercise our leverage by issuing recommendations, and indeed we rely on our reputational significance, actually seeking the eventual implementations of those recommendations, who can be either individual or systemic.
Right. So can you kind of lay out the framework, how, making a complaint before the ombudsman, what are the kind of qualifications of that the claim would need to qualify to be presented to you, and how you would choose which person would be the ombudsman for that case?
Right. The eligibility criteria, so to say, are pretty straightforward. You got to be a business, regardless of the size. And what you got to challenge is the instance of the business malpractice, which effectively is any action, inaction, or decision at the part of any public authority, including subnational governments or state-owned or communal-owned enterprises, who to any extent negatively affect the business's ability to actually carry out its statutory function. It's very simple. In terms of criteria as such, interestingly, in our rules of the procedure, the criteria has deliberately been elaborated in such a way that at the Business Ombudsman Council, we are obliged to accept into consideration all complaints, except for those that originate from purely private to private circumstances, or they relate to the merits that are being currently adjudicated or has already been reflected in the court decision that entered into force. We have kind of a statute of limitations, which is 1 year, but we employ this criteria rarely, in the sense that if we observe that the instance of business malpractice has a continuous negative effect, we would take it into account and still take it on board. We do have several stages in our work. The first one is kind of a prima facie review, 10 days after the complaint arrived, to ascertain whether it's generally eligible. And then if it is, we accept the complaint into consideration. It becomes a case, and we have up to 90 days to conduct our investigation. Having said that, the statistics proves that about 25% of our complaints what became case are resolved within 30 days. Wow. Because the typology of those instances is quite homogeneous. The scenarios do repeat itself. Some further 30% are resolved within the next 30 days. So that the number of complaints that require extension, whose investigation would be carried out beyond the original 90 days, is relatively small,
right.
From 2 to 3%.
I have so many questions.
Go ahead.
I'll start with two that are, well, I'll start with one and then I will logically move through them. But can you initiate one of these proceedings or, submit it to the council in parallel to any other proceeding? No.
This is effectively one of the criteria that makes the complaint not eligible. If you mean by parallel proceeding, you mean
like if a court case was going on, addressing a similar issue.
Or an arbitration, yeah.
Right.
No. Actually, any forum, if any forum is invoked, effectively it makes us no longer eligible to be considered as an option for the aggravated party.
Right.
Having said that, however, And this kind of demonstrates the nexus between what we are doing with both, I would say, arbitration and mediation, as a matter of the fact. And I will probably attempt to demonstrate how these three pillars of ADR can get together in terms of, or in the context of the activity that we are carrying out. Assume that, or this is quite customary, that in the circumstances where, let's say, our complainant who lodged the complaint with us has subsequently filed a notice of arbitration, and the cooling off period under the BIT or multilateral instrument kicks off, right? Then pursuant to the piece of a secondary legislation that we have here in Ukraine, the Minister of Justice is obliged to set up so-called intergovernmental working group, which is kind of an ad hoc platform aimed at ascertaining whether the possible settlement or reconciliation would be possible during the pre-trial stage. And it would be customary for the ministry to invite someone like me to sit in the composition of this intergovernmental working group, whose meetings would comprise both confidential and non-confidential part. The non-confidential is entitled to enable the claimant and its counsel to present the case. And I would sit there and in my capacity of semi-governmental official who still represents the body, which is equally distant from both business and government, it's kind of organic for me to sometimes step in and do a bit of a mediation exercise during that meeting. And the technique would vary from the conventional facilitative technique, which is just to facilitate the constructive negotiations between the parties, towards more persuasive technique, which would be very much descriptive of the function that, or authority that we are having at the Ombudsman institution, which is not to be shy about the merits. And if we are confident that we would like to support the position of the complainant, we do so on our own behalf, and we would issue individual recommendation. So that's how this triangle might, in the realities of this world, kind of come together and operate in one voice, so to say.
So just, sorry, Brian, if I just may ask a very general question, is how does one submit a request to an ombudsman? Do you need, do you refer to a clause, similar to an arbitral clause in the contract where the parties had agreed that if there's a dispute, we will first refer the matter to ombudsman, or is it an agreement that the parties have reached after the dispute?
Right. Let me answer as follows. First of all, because it's important in order to understand the context in which we operate, we are quite a unique institution in the sense that we have not been created by a one founding father, right? It's typical for the parliament to create a human rights ombudsman, right? Or the particular corporation or a university to have its in-house ombudsman. But still, the shareholder, so to say, is one. In our case, and that demonstrates how the utilization of ombudsman mechanism is evolving in the modern world, we have three groups that have set us up. And they are actually represented in our supervisory board structure. It's the government of Ukraine. Second are international financial institutions, namely EBRD and OECD. And the third group are local business associations. The idea back in 2014, when the respective resolution of the Cabinet of Ministers was adopted, was to sort of bring under one roof all stakeholders of the process of relationship between business and government in Ukraine together, and enable them to carry out the strategic management of the institution. These factors, together with the quality of the people who are working here, I guess, are indeed those elements of the reputational leverage that I mentioned earlier today, and which explains why, as a matter of the fact, we are so effective. Yeah, since May 2000. 2015, when we became operational, we received 8,524 complaints, out of which I actually have it handy. 2,500 has not been accepted into consideration because of those criteria that I generally mentioned. Currently, we are investigating 273. We closed against 5,684 cases, and 67 are currently in the prima facie review.
Wow.
The direct financial impact actually exceeds 18 billion hryvnias, which is more or less $700 million, I would say, something like that. We don't have such a KPI in our activity, but nonetheless, we have achieved that.
I really want to actually expand on some of these cases, but first, so to follow up on Sadia's question, so a party can effectively say, we don't want to go to this ombudsman, and then no proceeding would take place. Is that correct?
Absolutely.
Okay.
The idea to approach the business ombudsman with the complaint is purely optional.
And it doesn't cost anything either.
Yes, because, and this is another interesting element which explains the both hybrid nature of our institution and the preconditions for its success. Yes, indeed, our services are free of charge for the complainants. And the reason is because in reality, even our founding fathers, our shareholders, are not financing our activity. The financing comes from the European Union, and 13 countries who are allocating funds at the designated multi-donor account that EBRD maintains in London to finance several Ukrainian projects, including Business Ombudsman Council.
Wow.
So you see, it's actually in the conditions of jurisdictions like Ukraine, it's extremely important to maintain this financial independence, because it operates as a key precondition not only to hire quality staff, quality personnel, but also to operate without any elements of vested interest dependency, either from the complainant or from the state. And indeed, those complainants who are willing to approach us, they can do this freely by just filling in a very simple online form on our website. Indeed, some evidentiary base needs to be attached. The complaint can be lodged by mail. We are not depriving our potential complainants for any opportunity to approach us in a due course.
Right. And then do you, so everyone can go, it's boi.org.ua, and it's interesting because they have a tab for cases that have been actually considered by the BOC, and then also the actions taken and the results achieved, which I think is a very unique function. But so when you say investigate, because you get one of these complaints and then you say we investigate them, is it just an independent investigation based off the evidence, or do you mean investigate meaning you review the evidence presented and don't undertake anything independent beyond the evidence presented?
No, indeed, we would not limit ourselves only by a simple desk exercise whereby a designated inspector we call them inspectors or investigators, really, in English. The designated inspector to whom the case has been allocated, and by the way, once it has arrived and properly registered by our secretarial personnel, it's supposed to be distributed on a totally random basis. It can end up in the hands of any of the 16 inspectors that we have.
I see.
And in my position, by the way, I supervise activities of 6 such inspectors. Business Ombudsman does this with regard to 5 of my colleagues, and another colleague of mine, another deputy, has also 6.
I see.
To supervise. But indeed, apart from the analysis of the documents or any other evidentiary materials, we would set up meetings, we would send letters, we would engage in all possible ways of organizing active dialogue with the involvement of both the complainant and the respective complainee. We would actually, as a very natural platform for us, if exists, we would attend the administrative hearings, which is the pre-trial mechanism that exists at the level of, let's say, Ukrainian tax service, or at the level of the Ministry of Justice. And that would be a natural platform for us to express our position on the merits and issue recommendations and see how this is ultimately being implemented. Importantly, the recommendation can be issued either in course of the investigation in the form of the letter, or upon the completion of the investigation, it might constitute the part of the resolutory decision of the business-омбудсмен, which is the document we issue upon the completion of our investigation. And if recommendation is contained in the decision, it's not the end of the story, because we place it for the continuous monitoring, seeking its eventual implementation at some point in time in the future.
Do you have data as to how many of these recommendations have been successfully enforced since the creation, 2015?
Sadia, this is an excellent question. I think the number of individual recommendations that we issued vis-a-vis those individual cases nears 3,000. Mm-hmm. And the implementation rate exceeds 90%, which is absolutely amazing, given the fact that we are not the institution that is vested with binding authority, as we all now know, and which is probably just the excellent demonstration of the fact that if you structure reputational leverage right in the conditions of Ukraine as a, I don't know, Slavic post-Soviet jurisdiction, it might bring wonderful results.
And I'm sorry, I just also have a question as to that, because you talk about legitimacy, and I do think it's really important, and that's one of the key things that is under scrutiny in the arbitration world right now. You say there's around 60 or so investigators, as you call them. Do the parties have any say as to who is appointed? Do they get to challenge who's appointed? Is there like a declaration saying the investigator is conflict-free or something? Like, how did you gain that neutral, like, legitimacy in the eyes of the parties?
Investigators are those who are examining the merits and who indeed prepare our documents where the draft recommendation or another expression of the Council's view are set forth. But they are not adjudicators in the sense that this term is used in the ADR world with regard to arbitrators. They are operational officers in that sense, and they are not. They are indeed supposed to be unbiased and independent from both the complainant and complainee. And indeed, the institution's integrity is preserved by the fact that those complaints, once received, they are indeed distributed on a random basis. And if a particular individual inspector observes some elements of a potential conflict of interest vis-a-vis those matters that ended up in his hands, for instance, because the counsel or law firm that is acting on behalf of a particular complainant is his former employee, we would expect such an inspector to approach us in the management team, advise us about this, and we would make a replacement. But otherwise, the default approach is that it's actually good practice to ensure that complainants are not supposed to influence any elements of our operational activity. Moreover, when it comes to our independence on the operational level, it's important to emphasize that the supervisory board, comprising representatives of these three group of parties whom I already mentioned, they also are not, and I pledge they have never, during this almost 6 years of our activity, never intruded or any have affected the manner in which we, at the level of our management team, do day-to-day investigation of our complaints.
I also think there's a bit of a safeguard, considering it's just a recommendation and not a binding and enforceable decision that would deprive anyone of going to court or arbitration in the future. That you kind of, I mean, even if you're like, this ombudsman is biased, you could maybe kind of divert the rest of the case somewhere else. Could you just give us an example of one of the cases that you've worked on, just to, and kind of the recommendation you gave, just to kind of concretize what we're talking about?
I would try to. I would start by probably saying, and that would be probably curious for some of the listeners to see that more than 60% of our complaints that we receive right now are on a tax administration related topics. About 17%, and this is indeed unfortunate. This is somewhat descriptive of the peculiarities of the situation in Ukraine, but some 17% relates to the pressure that is inflicted by law enforcers against business. Some 15% of complaints are those that are lodged by businesses to challenge alleged malpractices as the part of their subnational governments, local, city, village councils, etc. The rest are the rest, as a matter of the fact, because we are the institution operating on the international, on the national level, and our mandate is specified in such a way that you can effectively challenge malpractices of anybody who falls under the category of public authority. Talking about the tax typology of the tax complaints, inadvertently I would have to become a bit technical here, but we receive. I will just look at the statistics of the previous quarter. We have such a scenario when you are the buyer and your seller is supposed to register tax invoice in the special electronic system to enable you to qualify for the VAT credit once this registration occurs. And once it happens, as a buyer, you have your so-called limits in the respective software increased, and this would be the limit that you could be entitled to utilize when you are acting as a seller yourself.
Right.
Sometimes, or this is quite customary right now, the tax authorities would block registration of such a tax invoice by employing various criteria, which at the end of the day be based on the allegation that the transaction was fraudulent, or that the particular party is not representing the real sector of the economy, that they do not have sufficient staff or the equipment. Another ramification of the same story is that, or the same problem is that some of those taxpayers who are approaching us would be included into the list of the so-called risky taxpayers. We have such an instrument within Ukraine's tax administration system. Another very unfortunate scenario is when following or actually without approaching us, by seeking judicial protection, the taxpayer will receive a positive court decision which would enter into force, and that would certainly be subject to enforcement on the part of a tax authority, which would be obliged to actually register the tax invoice, and the tax authority would fail to properly enforce such such court decisions.
So would your recommendations then be the tax court was wrong, or the administrative court was wrong, and therefore the company would take the decision, your recommendation to the tax court, and say, actually, you should treat us as a non-risky VAT? company?
We would indeed, depending upon when we entered into this scenario, if prior to lodging a lawsuit, the complainant were to approach us, we would, of course, if we are convinced, try to pass the message over to the tax authorities, utilizing our own argumentation that the complainant is indeed not a risky one, and there are sufficient grounds to believe, based on the following criteria, to consider removal of the tax payer from the list of risky ones. If we have not, let's say, been involved on this stage, and it has become known to us later after the taxpayer has successfully defended its interest in the court, we would treat the instance of the business malpractice in this case in a somewhat different manner. We would observe it in the fact that the court decision as such is not being enforced. So in the first instance, the malpractice is the frivolous decision to treat the taxpayer as risky. In the second one, malpractice is in the fact that, well, this matter has already been resolved. Yeah, the Ukrainian court has already opined on the merits. Therefore, the malpractice is in the failure to enforce such court decision.
Right. Interesting. I think this is, I mean, such a useful tool for especially in some smaller disputes, because I know that, for example, there's a ICSID case against Nepal now dealing with like a tax on a telecommunication company, and it had to go through all the way up to the Supreme Court and then into arbitration. And I mean, the value of that case was quite high, but I think, you know, in some small, I've seen cases in Saudi, I'm sure you have, where, you know, the amount in dispute isn't enough to justify starting an investment arbitration against a tax authority. And so to have this option, not only as a piece of evidence to bring to a later proceeding, but just to maybe give teeth to what the company is feeling, I think this is a unique opportunity for many companies, especially in, you know, any country, really. Indeed,
you're absolutely right that statistically speaking, 80% of our complainants are small and medium-sized businesses, 20% are large, but that's kind of a natural effect of how many, the number of small exceeds the number of large, right? This is the same proportion is maintained when you compare what is in terms of our complainants profile. 20% are, these are still Ukrainian legal entities, but owned by foreign investors, and 80% purely Ukrainian business. That's one thing. Another, when we were talking about our mandate, it's kind of would be important to emphasize that those merits that would, in the tradition of the Ukrainian administrative court, would not be regarded as a litigious circumstances, for instance, because the court would observe that the claimant is attempting to challenge the manner in which the public authority exercises the parameters of its discretion.
Right.
Well, but parameters are A, B, C, D, E, E, F, and any decision or action which falls within these parameters is legitimate. There is nothing to litigate about. Our mandate is broader, because we look whether this exercise was fair or not. And in this sense, the beauty of what we're doing is that not only we are a pre-trial institution, but we are actually broader than the conventional administrative court. I know from my colleagues that in many Western European jurisdictions, probably in most of them, it is really the practice of administrative courts not to accept lawsuits based on the allegation that the public authority has wrongfully exercised its discretion.
Absolutely.
Because it's not a litigious circumstance. Some do issue judges, courts in a smaller number of countries, they are not shy to say to a particular ministry or the agency, we want you to do exactly the following.
Mm-hmm.
In the Ukrainian tradition, it would be more to say this particular instruction number, blah, 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 or the order number, blah, 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 or a tax notification decision is illicit and has to be rescinded. But if the particular tax notification decision contemplates imposition of certain amount of fine, believe it or not, but it would be eventually left to the discretion of the tax authority whether, following the rescission of the tax notification decision, they would have to, as a matter of a restitution, repay the amount of fine that might have already been paid.
Right.
Maybe it's a bit too tricky.
No, I think, well, because what you're getting at, it's not only the breadth of the mandate, but it's also a different standard of review. Because if this type of case would go to investment arbitration, the standard would be denial of justice, and it would be a hugely high threshold for an investor to prove that the administrative court didn't just proceed through its mandate and decide unfairly, but they actually committed something amounting to denial of justice. Where your mandate, the standard is a lot lower, what you said, which is fairness. So you're able to get kind of a stronger argument because your threshold is lower. So I think it's not too technical. I think it's really interesting.
And the really last thing is that if we have to issue we have to complete our investigation without achieving successful outcome for the complainant, but we are confident in our approach in supporting the allegation of the complainant, we would close the investigation, of course, because we would have exhausted all means for a pretrial resolution, but we would try to be as much specific as it is possible in specifying our position on the merits in the kind of explanatory part of this decision. And the decision would be sent to both the complainee and, of course, the complainant. And the complainant is free to do with this whichever the complainant wants, namely to show it in front of the eyes of the administrative judge.
Right.
And if the judge is adequate, he would appreciate the fact that the Business Ombudsman Council has already gained the reputation of an equally distanced authority, which is respected. And the treatment of what we have written there would be like equal to or even higher than the attitude towards the view expressed by a respectable academia or expert in the field generally. So
it's not confidential.
It is in a sense that we are not entitled to leak the information about those guys that lodged the complaint with us. But of course, the documents related to the case are we are obliged to disclose them to the complainant, of course, and the decision is one of the inherent decisions, and then the complainant is free to do anything it wants with
so it's confidential. You have a confidentiality obligation, but the complainant, the parties between themselves, maybe they don't. Is my understanding correct that they don't, unless they agree, or is it that it is confidential between them as well? Like can the complainant use your decision before a court without the agreement of the other side?
Yes, because in this particular case, the determining factor is that the other side is the public authority.
Of course, yes, of course. So they're going to oppose to it otherwise. Yeah, okay.
Very interesting.
Yeah, I was going to say, I mean, maybe it's because we're obsessed with arbitration. Whatever you said, in my mind, it's like, whoa, that is like ground for a potential investment arbitration claim. I mean, maybe because it's only been a couple of years since you've created it, but I can imagine that there must be some recommendations that will be taken before an exit court, exit tribunal at some point as evidence of, what the conduct was or not arbitrary of the public authority. Maybe you will appear as a witness. Who knows?
That would be really interesting.
I have to admit that I'm also obsessed with arbitration. I am the fellow of the Chartered Institute of Arbitrators. The only thing is that I am not technically entitled to do any arbitration work either as an arbitrator or as a counsel, because that would constitute the conflict of interest under the Cabinet of Ministers resolution. But
as a fact witness, you'll be there. You'll be at an exit case as a fact witness,
right?
Yeah.
Well, in a due course, I guess. Yes.
Yes.
When I was graduating from that ICC International Arbitration Academy back in 2015, one of my professors told me that, Iaroslav, you have to spend 5 years working as a deputy business ombudsman, and then you will become quite a formidable source in the context of international investment arbitration.
Definitely. Well, I mean, we see the parallels quite clearly. So I echo your professor's sentiments. But thank you, Iaroslav. I think this has been really, really informative and giving us a unique perspective on other alternative dispute resolution mechanisms.
Thank you very much. Thank you.
Sadia, Brian, it was an absolute privilege. Thank you very much, and all the best with the podcast. It's extremely appealing to see that the original arbitration topic is being expanded to capture all the other facets of what is called ADR as such.
Absolutely. Thank you.
Thanks.